Hi, everyone. I wanted to discuss with you and put you in the know about Stephen Miller's outrageous comments on the suspension of habeas and give you information that I think you might not see elsewhere. So let's first just start out with Stephen Miller in his own words.
Well, the Constitution is clear, and that, of course, is the supreme law of the land, that the privilege of the writ of habeas corpus can be suspended in a time of invasion. So I would say that's an option we're actively looking at. Look, a lot of it depends on whether the courts do the right thing or not.
So habeas corpus is a fundamental right of all individuals in the United States to be able to contest their unlawful detention. And the first thing that might be important for you to know is that you may have already heard or read that the Constitution vests the ability to suspend habeas corpus in Congress, not the president. So it would be an extreme act for the President of the United States to say that he or she, in some other circumstance, could on their own suspend habeas. And that's why the suspension clause is actually located in Article 1 of the Constitution. So when Stephen Miller says that the Constitution is clear, he's deeply underinformed or trying to misinform you. And you don't need to just believe me. I think it's important to know, and here's one of the pieces that you may not have heard before. Justice Amy Coney Barrett is a scholar on habeas, and she wrote an article in 2014. I'm just going to quote for you a sentence from the opening of this law review article. The law review article is in the Cornell Law Review, and I'll put it in the show notes. But she said, quote, "There is virtual unanimity in the view that the Constitution vests Congress alone with the power to suspend," end quote. And in fact, her law review article is about a separate question, which is like how much of that authority could Congress potentially defer to the president? And she ends up by saying it's the Congress themselves that must determine that the country is under a rebellion or invasion, which is a required condition for the suspension of habeas. But the bottom line is that there is an accepted assumption, a premise to all those conversations, which is that it is Congress's power and authority and responsibility alone to be able to suspend habeas. A president should not be able to do so on their own, and if President Trump were to try to do so, it would be another aspect of this that would be an extraordinary, dangerous accumulation of power in the president, let alone it's not just an accumulation of power, but it's over the fundamental right of people to be able to contest their detention. So that's the first thing, just to know that there's something grotesquely unlawful about what Stephen Miller is saying in both dimensions, that the president can do this and that they would suspend habeas in the country when we're under no invasion or the like. Second is to think about who are the invaders in Stephen Miller's mind. And I thought that Laura Barrón-López put the context well last night on PBS NewsHour, which followed right after Stephen Miller's comments. So just listen to what she said on that show.
Now, the timing of Stephen Miller's comments is key here because of the fact that it's after judges have repeatedly ruled that the administration's actions regarding deportations are unlawful, and it also comes after a student just today was ordered released by a federal judge from detention after filing a successful habeas petition.
And so who is Rümeysa Öztürk? She is not an undocumented immigrant. She was released on habeas on Friday because she was held by the administration, even though she is lawfully in the country and a doctoral student at Tufts University. In fact, the judge found it was such an outrageous detention because the only basis that was ever given for her detention was a op-ed that she wrote. No other basis whatsoever. And the judge said this is a fundamental affront to the First Amendment, but it's also an affront. Imagine if she couldn't even have contested her detention or gotten to a judge. That's what stripping people of habeas rights entails. And if you don't think that Stephen Miller thinks of these individuals as part of the invasion and what he considers to be wrong with the country, I think that it actually fits very well as a puzzle piece with the White House, Stephen Miller, and President Trump's approach to birthright citizenship. Just think about the executive order. What was so extreme about the executive order is not just stripping individuals of birthright citizenship, which is enshrined in the Constitution in its text and has been recognized by the Supreme Court forever, but also that their version of the executive order would also strip people of their citizenship if they're born not just to undocumented immigrants, but to people like Miss Öztürk. In other words, to people who are in the country lawfully. I'll just read you a provision from the first section of the Birthright Citizenship Executive Order. It says it also applies, quote, when the person's mother's presence in the United States at the time of said person's birth was lawful, but temporary, such as, but not limited to, visiting the United States under the auspices of the Visa Waiver Program or visiting on a student, work, or tourist visa, which describes her to a T. And it's that idea that even children born to those individuals in the country lawfully would be stripped of their citizenship rights. So that gives you a sense of it. Also, if the President of the United States is able to suspend habeas, that would mean habeas for citizens and non-citizens alike. There's no reason to think that it would be restricted in the minds of the White House. So this comes just off of the heels of the arrest and detention of the mayor of Newark. I could imagine that the President of the United States, President Trump, might say, look, we're undergoing an invasion. This is a national emergency, so we cannot afford to give habeas rights to individuals and deprive local officials of their ability to contest their detention and get released. That's the kind of dangerous, slippery slope that we're on. All that said, I also want to end on a positive note. I don't think this is a forced positive note. I really do believe that Stephen Miller's comments are both foolish but also self-defeating. And what I mean by self-defeating is that his words are being listened to by federal judges across the country. I think that it will make them even more reluctant to ever embrace the administration's notion that the country is under an invasion. We've already seen judges stepping up to the plate on this particular issue when it comes to the invocation of the Alien Enemies Act, but I think now they can see the dangerous implications. Were they to ever accept that or defer to the president's determination that we're in an invasion, the logical implications are things like the suspension of habeas. And Danny Shulkin and I have a piece at Just Security. You can Google it by looking for a Pyrrhic victory, in which we recite a bunch of the federal court cases in which judges have now said this is no such thing as an invasion. This is a bogus invocation of the notion of invasion, both under the Constitution or under the 1798 Alien Enemies Act. One of the judges, for example, on the D.C. Circuit, Judge Henderson, who was appointed by Ronald Reagan and George W. Bush when she was elevated to the circuit, she said in an opinion, I want to quote her, because she referred to the one of the few arguments that the Department of Justice mustered. So she said, here we go. Quoting a dictionary over 200 years post-enactment, meaning post-enactment of the Constitution, the government claims that the term invasion, as used in the Alien Enemies Act, encompasses the arrival somewhere of people or things who are not wanted here. The text and its original meaning say otherwise. The theme that rings true is that an invasion is a military affair, not one of migration, end quote. Agreeing with her are other judges. Judge Sweeney in Colorado on an Alien Enemies Act also said this is not an invasion. Judge Hellerstein in New York also said this is not an invasion. Recently this week, Chief Judge Boasberg of the D.C. District Court said to the DOJ attorneys, isn't it true that, and then he just started reciting all of these other federal court judges that have come out saying this is not a proper invocation of the Alien Enemies Act because it's not an invasion. And isn't that where things stand, essentially, is what he said to the DOJ attorney. And the DOJ attorney agreed. Was trying to wriggle out a bunch of other things, but on that particular one, agreed. Lastly, I just want to recommend to you a piece that we also published at Just Security. It's a prescient piece because it was published in January of 2025 by Ilya Somin, who is a professor at the Antonin Scalia Law School at George Mason University. I'll also put this one in the show notes as well. And he talks about the dangerous implications of accepting the, not just rhetoric, but legal framework of an invasion when it comes to migration. And he goes through an originalist understanding of the Constitution and explains why that is not what invasion means. It's his kind of scholarship that's being picked up by these federal judges. And Ilya is also identifying the slippery slope, because back in January he already said, look, if you look at these executive orders, like the executive order declaring an invasion and things like that, here's where it could lead. And one of the implications he actually says is it could lead to the suspension of habeas. I'll just mention another thing he says as well. He says, look, if you take the term invasion, the Constitution also says that the individual states, like Texas, could actually take the country to war. They could engage in war under the Constitution if they face an invasion. He says that's not an issue for the next 4 years, probably in the Trump administration, because Texas is in lockstep with the White House. But in future years, why wouldn't the Texas governor and attorney general be able to say, oh, we're actually going to use force inside Mexico if we accept the term of invasion? So that's the kind of dangerous slippery slope, and in some ways it's a good thing that Stephen Miller has revealed to us where things stand and the dangerous precipice that we're on, because it's stiffens the back, I think, of federal judges, and it should also stiffen the back of members of Congress not to accept this terminology or to give it any legitimacy. So thank you so much for listening and turning into my new YouTube channel. If you're new here, please feel free to like, subscribe, and follow along. And I also look forward to comments from you all, in which I hope to engage you there as well. So thank you all for tuning in. Until next time.